Policy Committee will come to order. That is loud. Representative Bonner, would you lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Well, good morning, everyone. Thank you all for being here today. I want to especially thank our hosts, Representative Valerie Gatos, Representative Natalie Mihalik, and Representative Jeremy Schaefer for hosting us here today. I want to especially thank Moon Township for hosting us here. Thank you very much for welcoming us into your beautiful township building. My name is David Rowe. I have the privilege of serving as the state representative for the 85th Legislative District that covers Union, Snyder, Juniata, and Mifflin counties. I also have the honor of serving as the chairman of the House Republican Policy Committee. I would like to start off by letting our members introduce themselves and the districts they represent, starting with our host, Representative Gatos.
Valerie Gatos, 44th District here in Allegheny County.
Jeremy Schaefer, 28th District, Northern Allegheny County.
Brian Rosel, 56th District, Westmoreland County.
Good afternoon, Jill Cooper, 55th District, Westmoreland County.
Good afternoon, Natalie Mihalik, 40th District, Allegheny and Washington counties.
Hello, my name is Marla Brown. I represent District 9, and that's Lawrence County.
Tim Bonner, and I represent Mercer and Butler counties.
We're also joined online by Representative Brett Miller from the 41st Legislative District, representing parts of Lancaster County. So I want to first of all start off by talking about why we're here today. We're here today because the Pennsylvania Supreme Court has made clear that the Commonwealth must establish a statutory sentencing framework for second-degree murder, one that considers individual culpability. Our responsibility is to meet that requirement while continuing to hold offenders accountable, protect the public, and give victims' families a meaningful voice. As we consider sentencing safeguards, parole eligibility, and public safety, we must remember that these decisions are not merely legal or legislative. They have profound and lasting consequences for the families of those whose lives were taken. To ground today's discussion in that reality, I would like to begin by sharing two letters from two members of one victim's family, his wife Stella Getkin and his sister Christina Hickman. The first letter by Mrs. Getkin. My husband was murdered by Raymond Peake 16 years ago. He was sentenced to life in prison with no possibility of parole for second-degree murder after a nolo contendiere plea. Our pain and sorrow are never far from the surface, and the thought that the person responsible for taking Todd's life may be released from prison is unbearable. My son's life changed completely on July 21st, 2010, at the tender age of 6 years old. That morning, his father dropped him off at the YMCA summer camp in Camp Hill, both not knowing it would be the last hug, the last goodbye, the last I love you. He asked me why the man killed his father. I told him that the man wanted his dad's rifle and that he was using it at the range. My son then said, why didn't he just ask Dad if he could borrow it? Dad would have let him borrow it. He didn't have to kill him. I had to explain to my young son that there are certain people who are capable of acts so violent and cruel that they cannot be trusted to live among us. I told him this with the confidence that Todd's murderer would never be released from prison. Now we have to relive that trauma all over again. Todd was a devoted father, committed husband, son, brother, and uncle. He was an attorney in Dauphin County, and we made our home in Enola, Cumberland County. He was born and raised in Lycoming County, was valedictorian of his high school, and graduated with honors from Penn State. He served in the U.S. Army, 10th Mountain Division. His family didn't have a lot of money, but he worked hard, played by the rules, and became an attorney. I tell you all of this so you know the kind of man who was taken from us. I don't have a fancy title, I'm not wealthy, and I don't have power. I'm a mom and a widow who is hoping that those who are in power make the right decision and keep this murderer in prison. It's frustrating to hear the words fairness or compassion being applied to a murderer's sentence. Where was the fairness or compassion when that man decided to end Todd's life? The loss my son experienced and continues to experience is unfathomable. No father to ask for advice or talk to about life's joys and disappointments, go on trips with, or share milestones with. I worked tirelessly to raise him to be a responsible, caring, generous, and resilient young man. It wasn't easy as a single mom. He is graduating this summer from the University of Pittsburgh with an electrical engineering degree. He's endured more suffering and hardship than any young man should have to experience in his formative years. I want you to explain to my son why you want to show compassion to the person who took his father from him at such an early age. Please show the same compassion to my son and my family who follow the laws, play by the rules, work hard every day, pay taxes, and contribute to society. Raymond Peak was 64 years old when he murdered Todd. He has served 16 years of a life sentence. He is 80 years old now, but he should continue to serve out his life sentence for taking a life. I am pleading with you to draft legislation that would ensure that those who committed murder continue to serve out their life sentences with absolutely no chance of parole. I want your commitment that you won't support a bill that would allow Todd's murderer an opportunity for freedom, an opportunity to spend time with his family, opportunities he took from my son and my family. Please think of your own children and imagine their lives if they had to grow up without you. That's the life my son has lived. Regards, Stella Getkin. I'd also like to read the letter addressed to Representative Gatos from Christine Hickman. Dear Ms. Gatos, I am writing in regard to the recent ruling by the Pennsylvania Supreme Court, who recently ruled on the subject of the second-degree murder life sentence of Derek Lee's appeal in Commonwealth of Pennsylvania v. Derek Lee. My family would like to urge the Pennsylvania House of Representatives to produce a fair and just bill to address this ruling. This ruling seems to have no compassion for the victims or the families of victims. These people sentenced to life either pled guilty or were convicted in a court of their peers to these heinous crimes. Life in prison for most of them was a very fair sentence. The victims did not get that option of life, they got death. These offenders should not be resentenced, paroled, pardoned, or their sentence commuted without going through the whole appeal process. They should not be able to receive a reduction of their sentence because of one Supreme Court ruling. My brother, Todd Getkin, was murdered on July 11th, 2010 at a shooting range in Cumberland County, PA. Todd was a resident of Enola, a father, brother, son, husband, and friend to many. He was a practicing lawyer in the area. The man who murdered my brother pled no contest to the charges of second-degree murder and theft. He received life in prison for the murder and 10 years for the theft of Todd's gun. He shot my brother numerous times in the back at the shooting range just to steal his gun. The man filed numerous motions and appeals over the last 16 years, and they have all been denied. He was 64 years old when he committed this heinous murder. He has been incarcerated for 16 years. My brother has been gone for the same 16 years, but he didn't get life, he got death. Our family does not think this man deserves or should be eligible for resentencing, parole, pardon, or commutation of the heinous crime he committed. Our family will never see Todd again. His wife will never have Todd by her side again, have a conversation, a hug, or a kiss again. His son will never know how wonderful his father was. He was only 6 when his father was murdered. He is now 21. Todd will be forever 42 and never know how his son has grown into a wonderful man. The family is pleading with the legislature to stop the Supreme Court ruling and produce a bill to address the second-degree murder sentencing ruling. Every case should be investigated on a case-by-case basis and be made to go through the court's appeals processes. These people sentenced to life got to live. The people they murdered got death. Please come up with a bill to fairly address the second-degree murder ruling fiasco. Our families worry every day that the man who murdered our brother could get out of prison. Sincerely, Christine Hickman. I want to thank both of these women for sharing their story with us. I'm sure it is a difficult and traumatic experience to relive those memories, but your testimony is why we are here. Your challenges are what we are here to tackle. Their experiences really must remain at the center of our work as we pursue a sentencing framework that delivers justice, protects our communities, and respects victims' families. At this time, I'd like to recognize our host, Representative Gatos, for some opening remarks.
Thank you, Mr. Chair, and thank you for reading some of those letters that were really heartfelt. And that's generally why we are here, because my office had received letters from a number of constituents. There were a couple who we asked if they wanted to even submit testimony, and they said it was too hard for them to even bring this up. And that's why we're here. We're here to represent our constituents who are concerned for public safety. So I want to welcome everybody for participating in this House Policy Committee hearing, and this is really an issue that it affects us all across Pennsylvania, and it's about accountability and justice in second-degree murder sentencing. And I thank the policy chairman, Dave Rowe, for putting this together and bringing this important issue to a hearing in the district and giving the opportunity to our local DAs and the surrounding areas to be able to testify, and also some victims advocates and others in law enforcement. I also thank Representative Mihalik and Representative Schaefer for participating in this because they're my colleagues here in Allegheny County. And I'm particularly pleased to have Representative Mihalik here because she began her career in the Allegheny County District Attorney's Office and has worked with victims, crime victims, as well as pleased to prosecute these criminal cases and put violent offenders behind bars. As the chairman said, is that prior to the Supreme Court decision that anyone involved in a deadly felony was sentenced to life in prison. And I know a lot of people said that, you know, even if they had no involvement in the killing, that they were given these felony sentences of second degree. We certainly are a nation of individuals, and every case has its own facts, and we certainly recognize that. We recognize every person's level of culpability is different in these things. That's what makes this issue so complicated. This hearing is not questioning the Supreme Court's ruling necessarily. This is about creating a responsible framework, going forward to hear the opinions and stories of our constituents, our district attorneys, to create a responsible framework that considers the different degrees of responsibility, but while never losing sight that a life has been taken in whatever crime that had occurred that was given these sentences. And while House Bill 1042, which was what brought this up, was intended to address the constitutional concerns for both victims and the convicted, and it was a bipartisan bill at one point, the changes in the amendments to this legislation created new sentencing framework that could allow individuals convicted of second-degree murder to become eligible for parole without serving what many would consider the proper time. And here we are to discuss what is that proper time, what is the proper framework. The Senate did address some legislation that was bipartisan, and it was from the input of the Attorney General and law enforcement and victims' rights group, and they came up with a solution. But unfortunately, it was not taken up by the House to effect the change that it needed at the time. And the House bill was amended, and precisely because it was amended, the result was not meeting the deadline imposed. So the bottom line is that we need a thoughtful, just process. And whatever framework that is established, it must be constitutional, it must provide meaningful accountability, it must protect the public, and it must ensure that victims' families have a voice. That is precisely why we are here today, to examine what changes could mean for public safety, what the changes that were made could mean for public safety, and what are the changes that we could be making to enhance public safety and the safety of our victims across Pennsylvania. So I look forward to hearing from our testifiers today on how Pennsylvania can get this right. So again, we are here to get this right, and that is the most important, is that people want problems fixed, and we want to fix them, and we are here to hear from people to provide us solutions. Thank you again for everyone being here, and thank you, Chairman Rowe, and I'm looking forward to a thoughtful discussion.
Thank you, Representative Gayos. Representative Mihalik.
Thank you, Mr. Chairman. Thank you to Representative Gatos and her staff for putting this all together today and identifying the testifiers that are going to share with us, you know, their experiences and help guide the legislature into getting this right, because that is what we are looking to do. And we're not only looking to get this right, but I think it's our duty as, you know, public officials and members of our own communities to communicate with our constituents and with the residents of Pennsylvania on exactly what this is, what it's doing, and what the impact is. And I just want to address the elephant in the room for a moment, because I think that there is a ton of misinformation in the public sphere about what House Bill 1042 really was. So I have been in this role for 8 years. In my prior life, I was in the Allegheny County District Attorney's Office, and I know a number of you here today. I feel like it's a little bit of a reunion, and I appreciate the work that you've done with the victims on behalf of the Commonwealth of Pennsylvania. In my 8 years, I have had a lot of disappointing moments in the legislature, and none more disappointing than day 119. So the Supreme Court gave us 120 days to fix this issue. On day 119, when we were called into Harrisburg, and at the 11th hour, amendment after amendment after amendment was shoved into a bill, and I'm guessing my colleagues are not even aware of this, that was originally my bill. We had all these various amendments having nothing to do with actually resentencing the defendants who were serving life sentences on a felony murder charge. And that is kind of what's led us here, because now we are well past that 120-day clock. I know there was an attempt made by our local district attorney to extend that time period, and it had been denied by the court. Regardless of what action we take, there are going to be a lot of resentencing hearings, and it's going to be difficult for the courts to manage that. It's going to be really difficult, as you heard from these letters from the victims' families, because they're not even able to come and reopen these wounds and talk about it in these settings. And now they're going to be forced to do that to ensure that the perpetrators that destroyed their families are not able to get out of prison. Day 119 of that clock, I found it to be just so disappointing and really so divisive on something that shouldn't be. And we're talking about defendants serving life sentences for felony murder, and political games were played with those defendants and with those victims' families. And I have never been more disappointed in the leadership in the House of Representatives than I was on that day. So we're here to set the record straight, hear directly from law enforcement and from the district attorneys and the victims' advocates as to what are the impacts of this and how we can get it right in Pennsylvania, because we have to. This has already been, we've already blown the deadline, well past the deadline. And at this point, we need to do something to ensure that we're taking the steps forward to protect those victims' families and to ensure that justice is served. So I appreciate the policy committee for setting all this up. Valerie, thank you again for bringing us out to your district and getting this testimony before us today so that our colleagues can review it and make the right choices moving forward.
Thank you, Representative Mihalik. Representative Schaefer.
Yes, I want to also thank Representative Gatos and Representative Mihalik for all their work on this important topic. I'll echo Representative Mihalik's words. It's very frustrating that we're here today. There was a bipartisan solution that passed the state Senate, and it did lose votes on the right and it lost votes on the left, but it was a compromise, a bipartisan solution that the state Senate passed. It would have passed the state House. Unfortunately, there are active groups out in our community. You hear the DSA, they have a platform. They want to defund the police. They don't believe prisons should even exist. That they had undue influence over this bill in the state House, and it resulted to where we're at today without being able to have a bipartisan compromise. So I look forward to hearing from our testifiers on how we can move forward here and try to get a solution that helps protect the citizens of the Commonwealth.
Thank you, Representative Schaefer. I want to recognize we have been joined by Representative Barb Gleim from the 199th District representing Cumberland County. Thank you, Representative Barb Gleim, for joining us online today. I want to welcome our panel of testifiers today. Thank you very much for taking the time to join us today. First of all, we have Ronald Wabby, who is the Deputy District Attorney with Critical Case Review in the Appellate Division for Allegheny County. We have Nicole Ziccarelli, who's the District Attorney for Westmoreland County. And we have Robert Manzi, who's the District Attorney from Indiana County. Thank you all very much for taking the time to be here today. I also want to note that we also have written testimony members in your packets from the PA State Troopers Association, as well as the Fraternal Order of Police Lodge 91. As we talked about before, I'm going to turn it over to you guys for testimony. 5 to 10 minutes each would be great, and then we're going to open it up to questions from the members. Deputy District Attorney Wabby, you're up first.
Thank you. On behalf of Stephen Zappala and the Allegheny County District Attorney's Office, thank you for having us participate in this. The Supreme Court decision in the Lee case basically changed decades worth of law in this Commonwealth. And as a result of that decision, there's thousands of defendants and victims the sentence has been cast into doubt. The victims' families do not know what's about to happen to them. In order to prevent chaos, which will be the result if a new sentence scheme is not created, the Allegheny County District Attorney's Office sought a stay in the hopes that the legislature would pass a bill that will allow us to solve this problem. Unfortunately, that did not happen. And as a result, we're going to have to move forward. The lead case is Allegheny County's case, and as a result, we're going to address this probably long before anybody else. We currently have over 160 individuals who were convicted of second-degree murder, dating back to the 1970s. So as a result, there are thousands of families out there, thousands of victims' families who have no longer a finality in this decision. And as someone who, after the Miller decision, there was a push to resentence all the juvenile lifers in Pennsylvania. Resentencing those individuals, what could have happened is the legislature could have acted then, solved the problem, made it retroactive, and that's not what happened. They only looked at a forward-looking solution. As a result, every single individual that was convicted of murder as a juvenile had to be resentenced. Allegheny County had the second most in the state. I spent 4 years of my career tearing apart victims' families by making them relive events that happened years ago. The oldest one I dealt with, there was one from 1968. There was an additional one from 1970. The one in 1970, I actually was able to bring in the victim's family, and they came in after 50 years to testify about what had happened to them. If there's not a good solution, a solution that works where the victim's family's lives are not ripped apart, we're going to be doing this again, where there's no finality in the convictions. And understand what finality really means, okay? It's not the end of the day when somebody gets sentenced. There's a long appellate process. There's a post-conviction process, which the House bill reopened unnecessarily. And this lack of finality carries forward for years. I have been with the Allegheny County District Attorney's Office since 1998. I've been in the appellate division since 1998. I have handled cases for decades, and they still keep going. I did one recently that I've handled for over 20 years. There is no finality that I can give a victim, but doing what we're doing now, where a victim is now being forced to relive events decades later, there's no, I can't explain to you the pain I saw in these people's eyes when I had to resentence, talk to them. I mean, it's one thing reading a letter, and I really appreciate what the victims wrote, but it's a different thing to stand next to them when it happens and to watch the look on their face when they're looking at something, pictures from 1970s, and saying, yes, that was my sister, and this is what happened to her. And that is what's going to happen if there's not a solution that either paroles some of these people with a term of years, or follow what the state Senate did and have a sentencing structure that creates something where they do at least 35 to life, and there's some things that allow it to go higher. It's the only way to solve it. But parole for the people that have already been serving sentences is the only solution that's going to prevent mass resentencing. But I mean, that unfortunately is not a decision that's mine to make. And I'm going to have to live with the consequences. And the victims are going to have to live with those consequences. And I'm telling you from experience, it was a horrible event that I had to do that to these people. And I don't want to do it again. Like I said, I spent 4 years doing it.
Thank you very much, and thank you for your work. I just reading those two letters for the first time was not easy for me, so I cannot imagine what you go through every day facing these sorts of horrific scenarios. So thank you for your work. District Attorney Ziccarelli.
Thank you. Good afternoon. Thank you to Chairman Rowe, Representative Gatos for hosting, and all of the members of the Pennsylvania House Republican Policy Committee for inviting me to participate in today's hearing. As a member of the Board of Directors of the Pennsylvania District Attorneys Association, I appreciate the opportunity to share our perspective on second-degree felony murder sentencing and the consequences that continued inaction will have on victims' families and on the safety of communities across our Commonwealth. For those who may not know me, I am the District Attorney of Westmoreland County, currently serving in my second term. I oversee an office of 24 attorneys, 14 county detectives, legal secretaries, and a handful of victim witness advocates. As district attorneys, it is our duty to not only protect and preserve public safety, but to be the voice for victims of crime who have often been harmed, hurt, and traumatized. It is these victims who carry the burden and the trauma from the crimes committed upon them, and it is our duty as prosecutors to vigorously fight for justice and hold offenders accountable. One of the most important yet difficult responsibilities of being a prosecutor is helping families who have endured the unimaginable loss of a loved one to murder and understanding how offenders will be held accountable. They ask, will the person who killed my family member go to prison? For how long? Could they be released someday? Will my family and my community be safe? These are not abstract questions. They are the foundation of victims' sense of justice and security. It is, quite frankly, disheartening and disappointing that a deadline passed without any clarity or measures in place to provide the framework and guidelines for judges when sentencing some of the most egregious offenders. The Senate passed legislation twice to fix mandatory minimums to ensure criminals remain incarcerated. Instead, the House narrowly passed a watered-down version that comes as an injustice to victims and their families. These are offenders who committed violent, heinous crimes, and by giving the opportunity to petition for release, it greatly jeopardizes every aspect of public safety. It is also a disservice to the justice system and the taxpayers in the Commonwealth who will be forced to foot the bill for ongoing court proceedings if 1,100 inmates should be considered for resentencing or possible release. Failing to act on a legislative framework for second-degree murder is a failure for the victims and their families who entrust our government to hold violent offenders accountable and uphold law and order. As an example, in Westmoreland County, the sentencing of a defendant who was convicted of second-degree murder is currently hanging in the balance of legislation to address the Supreme Court's decision in Commonwealth v. Lee. The defendant is scheduled to be sentenced on Monday. Instead, our prosecutors are preparing for the unknown. If the judge decides to use his own discretion in sentencing the defendant, it could prompt appeals from either side for an unconstitutional resolution without legislative framework and a sentencing scheme in place. Latrice Williams was convicted by a Westmoreland County jury in December of 2025 for killing and attempting to rob another man in New Kensington, who he believed carried a large sum of cash and drugs. The victim was found shot to death with multiple gunshot wounds inside of his vehicle in an abandoned housing complex. The victim, Anthony Williams, was 31. He was the father to 5 young children. The victim's family waited 5 long years for that verdict, and they are still waiting for justice as Williams' resentencing remains on the table, waiting for direction from the legislative body. At the very least, these families who have been tormented by crime and trauma are at least owed some clarity and uniformity when it comes to the courts. Not only should Senate Bill 1400 be brought to a vote, the final bill should include the following: expressly preserve crime victims' statutory rights to participate in the parole process for these cases, and explicitly protect the finality of existing plea agreements to second-degree murder, many of which were negotiated specifically to take the death penalty off of the table, with the understanding that of all of the parties that the resolution was final. An inaction on this bill will be detrimental to the safety of our community, to the victims, and to the integrity of the criminal justice system. Prospectively, it is my belief that a penalty for second-degree murder should include a mandatory minimum and life without parole maximum. While it is vital that judges maintain discretion in sentencing, the most violent offenders should be sentenced to life when the circumstances of that case call for it. Retroactively, the Pennsylvania Board of Probation and Parole should be allowed additional time to act on or reconsider cases that would be eligible for parole. Each case file will need to be individually reviewed, and given the statewide volume, it will be time-consuming and taxing on the system. Thank you very much for the invitation to speak before the committee today. I hope this brings some understanding and insight into how critical this piece of legislation can be to upholding justice, protecting victims, and defending the integrity of the criminal justice system, while also preserving public safety. Thank you.
Thank you very much. District Attorney Manzi.
Thank you and good afternoon. First off, I want to thank the members for putting together today's event and for inviting us here to speak. I also want to thank the members of our legislature, both in the House and the Senate, that took this matter seriously and twice passed a bill in the Senate and did a great deal of work in the House to try to get this to the finish line. Your work is not unseen. It's unfortunate that we're here today because we're talking about second-degree murder. We're not talking about some minor nuisance crime somewhere in some other community. We're talking about second-degree murder. And I think it's important, I agree with the statement earlier that there's a lot of misinformation. Second-degree murder means, if you're convicted, that the jury, the judge, or by your own admission, you were a principal or an accomplice in the commission of a robbery, a rape, deviant sexual intercourse by force or threat of force, arson, burglary, or kidnapping. What that means is you actively agreed and took a substantial step to committing a violent felony, and a foreseeable outcome, the death of another person, occurred during the commission of that crime or your flight from that crime. And I believe it is lost in all of the information out there that we are not talking about an innocent person sitting in the passenger seat of a vehicle not knowing what their buddy's doing inside a gas station. What that means is we have individuals who actively agreed to participate and take a substantial step in a violent felony, and a foreseeable outcome happened. We talk about these crimes, but we don't talk about them in detail enough for people to realize what they are. I represent the citizens of Indiana County. I have a much smaller caseload than a lot of other counties, but nothing is less important. In our county, our second-degree murder convictions include a young man that came from a different city into our county to party at our university. They ran out of drugs, agreed with 3 other individuals to call a drug dealer to come over to sell him $10 worth of marijuana. He walked out of the apartment complex with a gun in his belt, pulled the gun out, shot him, and let him die on the street. That's second-degree murder. We have another individual who, along with 2 co-defendants, went into an apartment building and bludgeoned to death 2 victims. We have another individual who helped participate in tying up a victim, stabbing him over 80 times, and leaving him to die with a 4-foot sword in his head. This is second-degree murder. This is what we have to work with in our criminal justice system. I hope moving forward, maybe we move the prism that we're looking at this for, because victims not only should have to deal with this in the first place, but when they do, they want to get to that finish line and they want to know that it's done. And maybe we have to rework this and look at it through the eyes of what's right for a victim's justice system. These victims' mothers and fathers, fiancés, spouses, and children should never have to go through this. And when it's done, they should be able to pack that away and never be bothered by that defendant again. So I thank you for all your work, and I really do appreciate the opportunity to represent Indiana County here and to answer any questions that you may have. Thank you.
Thank you very much to all three of you. Before we move to questions, I do want to mention, I neglected to do so, members in your packets as well. We also have written testimony from John Rago. He's a professor of law at Duquesne University Klein School of Law. He's also a member of the Pennsylvania Commission on Sentencing, and he's the chair of the board for the Center for Victims, which is Pennsylvania's largest victim service organization based in Pittsburgh, just nearby. We're also joined today, thank you very much for being here today, by Lori McDonald. She's the president and CEO of the Center for Victims, as well as Stephanie Fox, who's the director of government relations for the Center for Victims. So thank you, both of you, for all the wonderful work that you do for people who are struggling. We are very glad to have you here. We're going to move to questions from members. As I mentioned, members may ask you questions individually. As a whole, we are here to learn from you, so you don't have to answer any question, but feel free to answer any question because you guys are the reason we're here. We're going to begin with our host, Representative Gatos.
Thank you, Mr. Chair. So as we talked about, that this is all about fixing this problem. The Supreme Court gave the legislature 120 days to act on this, and we talked about that they failed to act, even though there were some solutions. I saw that our Attorney General, the District Attorney Zappala had requested a 120-day extension, again, trying to say, hey, look, we want to get this right. It's not that, we want to fix what's wrong. So he had submitted a request to extend it another 120 days, which again would enable us to get this right. And unfortunately, the Supreme Court had denied that with a simple, I understand, one sentence, no. And so what are the next step? And I guess this is for all of you as DAs that what is the recourse, and and this is why we're here today, is to say, ask what is it that we need to be doing, and immediately.
Unfortunately, the first thing I'd say, there is no recourse. The Allegheny County District Attorney's Office has appealed as far as we can go. Based upon the way that decision was rendered, the Supreme Court decided that it was decided on state constitutional grounds. So there is nowhere for us to go. As a result, we are forced to face what we're going to do with Derek Lee relatively quickly. And as a result of that, with no framework in place, it leaves absolute discretion to what the trial judges are going to do. And much like Westmoreland County, we have other secondary murder convictions that are pending too, which means that we're going to just do senseless sentencing and then senseless appeals until this is resolved. Because the Supreme Court is going to determine this is retroactive. There are cases before them right now, at least one that I know of, that decision's coming. This is similar to what happened with Miller. Everybody thought it wasn't retroactive, and then it was. So it's coming. So a solution from the legislature prevents chaos from every judge in the Commonwealth sentencing somebody however they want. And I think you realize how dangerous that can be. You're not giving the victims any closure whatsoever. And all it's going to do is multiple appeals for no reason whatsoever. And it's dangerous. You're dangerously putting convicted murderers back on the street without any recourse.
The other thing I would note is, and you kind of touched on this, it's going to depend on the judges in each individual county. So people are going to be treated disparately in every county across the Commonwealth. And that's very dangerous because there will be no uniformity. We will still have no idea what's going on. It will create chaos and violent situations in our communities. So that is very, very dangerous. That scares me a great deal. That's something that keeps me up at night because people will be treated disparately across the Commonwealth of Pennsylvania. And I think we're better than that. And if we don't have a legislative solution, that's what's going to happen.
So the lack of uniformity seems like that's unconstitutional.
One other thing I was going to comment on, to go back to the uniformity. As a result that there was no legislative solution last time when the juvenile lifers were resentenced, the Supreme Court decided how it was going to work. In Allegheny County, there was one judge who concluded that he could sentence the person however he wanted. He sentenced the person to 7.5 to 15 years for murder. And we had to appeal that in order to establish the idea the statutory maximum was going to be life and that they were required to sentence from a term of years to life. And a similar situation will occur now because there's no framework to accomplish anything. They will do whatever they want. If you're going to get rogue judges in different parts of the state, they could do anything they want. It's a frightening concept.
So you're saying that people can then over-sentence as well?
They could over-sentence. They could give probation for murder. there's no floor, there's no ceiling.
Thank you, Representative Gatos. Representative Brown.
Thank you, Chairman, and thank you all for being here. We certainly appreciate your testimony, and it just blows me away why there isn't more public outcry over what has just happened. The irresponsibility of the House of Representatives playing political games over such a vitally important issue. I'm interested if any of you had a chance to review the Senate bill and if you thought that it was sufficient moving forward. And if not, what should we have supplemented it with?
Thank you. So, being a member of the Pennsylvania District Attorneys Association, I currently serve as the Secretary Treasurer for the association, and we were supportive of that bill. I believe that it focused properly on the idea of at least a mandatory minimum of 35 years. Certainly, there's going to be folks that would have wanted that number to maybe go up a little bit or down a little bit. But I think generally that idea there, individually, I'll speak for myself. I believe that robbery should have been given a little more emphasis than it was. But overall, I thought the bill was very well worked. I thought that the idea that we're going to be able to put those serious offenders away still for life, or at least 35 years, it gave victims the idea that, it's going to be a lifetime later when that person even has the opportunity to be out. One of the matters that I believe is important in there was talking about how the paroling aspect could be in resentencing, understanding, and I agree that the retroactivity is going to come. Being through the parole board, if you have individuals resentenced at the Court of Common Pleas individually for our counties, what that means and what we fear is that's now going to reopen all of those various appellate rights that they had when they were initially sentenced. So now you have a case from, let's say, 1995, where that person has been away, they've been serving life, that file is in storage somewhere. The individuals who've worked a case are at least retired and may not even be with us anymore. But now we have to go back and worry about all of the various appeals, all of the post-conviction rights, and all of those extra steps that are going to happen if it is resentenced, as any other resentencing might be. And what that means is, it has an effect further than those cases. For every case that we have, that's many hours between our attorneys, our county detectives, and respective police departments that are now focusing on a resentencing from 1996 and the appellate rights there, when we still have people out in our community right now committing crime that we can't focus on them. There's only so many hours in a week. There's only so many people on a staff. And when we have to dedicate time unnecessarily to a situation like that, it creates an unsafe situation now, because that means there's current cases that just functionally cannot get the attention it deserves.
Just wanted to note one other thing about the DA's Association. So of the 67 counties in Pennsylvania, 66 district attorneys are members of the association. And I will say that members from both sides of the aisle in the DA's Association worked very hard and got to a place where it wasn't perfect for some, it wasn't good enough for others, but we all kind of got behind Senate Bill 1400 because we realized there had to be a solution and we had to come to some kind of compromise. So I just wanted to make sure that I expressed that. And to Bob's point about the time aspect, we all know that the work that prosecutors do is not in an hour of law and order. And it goes on and on and on, as you had mentioned. And so you've got to try to figure out, what are we going to do when we cannot address crimes that are happening today because we're faced with resentencing for very violent offenders? These are not the getaway drivers. Let's be clear about that. I hope we've made that point loud and clear today.
Yes, and thank you for that. I want to apologize on behalf of the House of Representatives for this irresponsible and careless decision-making. And I want to thank you for the work that you've done, because this is ultimately a slap in the face of everything you've done for these victims' families. And we will get it fixed. Thank you.
Thank you, Representative Brown. District Attorney Ziccarelli, you mentioned there were 66 out of 67 district attorneys. Can you tell us who the one member that is not?
Philadelphia.
I think that's very important for people to understand. Also, when we look at to Representative Brown's point, I think every single member of, well, I know for a fact, every member sitting at this table voted against the bill. So we are obviously advocating to correct it. But we all voted against this bill that was, unfortunately, the leadership of the House is almost exclusively members of the Democratic caucus from Philadelphia. I think that's an important thing for people to see.
Thank you, and thank you for that, because I know you did your job. But if you look at Philadelphia, there's over 500 cases in Philadelphia. You want to talk about people being treated disparately? You want to talk about danger on the streets? Worry about Philadelphia.
Thank you. Representative Mihalik.
Thank you, Mr. Chairman. I did want to point something out, and then I do have a couple of questions for the panel. So I was just up here taking a look at the final version of House Bill 1042. And I just want to note for the record, it's 53 pages. The first 19 pages was stricken language, meaning they lined it out and they replaced it with something else. So we're down to 34 pages. Of that 34 pages, to address this very serious problem, 19 of those pages were used for medical parole, which is not anything to do with second-degree murder. It has nothing to do with the court telling the legislature, you guys have 120 days to fix this unconstitutional statute. So they dedicated, out of those 34 remaining pages, I just want to point out again, 15 were dedicated to medical parole, which is neither here nor there as far as I'm concerned. And I know it was a reason that many of us did come to a no vote. I think it's important, it's kind of a review for me, and I didn't work in appeals when I was at the district attorney's office, but I think it might be important for myself and my colleagues to just understand a little bit more in depth on the appeals process. So maybe, Ron, if I could start with you, maybe you talk about that other court decision and just the process for resentencing all those juvenile lifers when that other statute was ruled unconstitutional.
Okay, thank you, Representative. So what decision I was talking about is Miller v. Alabama. It was the decision that determined that juveniles could not serve life sentences for murder. Okay, so as a result of that, Allegheny County was forced to resentence approximately 50 juvenile lifers, of which I did 90% of them. There's like 10 I didn't do. What that does, okay, in every single case, okay, every single case, whether they plead guilty or they're convicted, the defendant has an absolute right to an appeal. That appeal goes from the state to the state superior court to the Supreme Court. Okay, they have the option of appealing to the Supreme Court of the United States. Then it comes back down for what's called a Post-Conviction Relief Act petition. And what that petition does, it's the ability for the defendant to then challenge their conviction in a variety of other ways, including after discovered evidence, the ineffective assistance of their trial lawyer, and other things. From there, that decision gets decided, that case gets decided by the trial court, then again back to the Superior Court of Pennsylvania, and then back to the Supreme Court of Pennsylvania, and then possibly the Supreme Court of the United States. But it's not over. At that point, they have the option of going to federal court, and they file what's called a federal habeas petition. That federal habeas petition is dealt with in front of federal court, then the Third Circuit Court of Appeals, and then the Supreme Court of the United States, possibly. So that's just the basics of appellate practice, okay? In reality, there's multiple levels where people find people in prison or whatever, and these cases continue to go on and on. But back to the juvenile lifers, just to understand what resentencing would do. After several years, those cases would then, even using the secondary murders, if they had to be resentenced, they would have the ability after several years to file another direct appeal challenging the sentence that was imposed, go back to the Superior Court of Pennsylvania, then the Supreme Court, then come back down and file a PCRA challenging the sentence that was imposed based upon ineffective assistance of the resentencing council, which has happened with the juvenile lifers. Then again, back to Superior Court, back to the Supreme Court. But what they're not, the other thing that happens in this whole mixture is the idea that once they're resentenced, federal court gets jurisdiction again because resentencing equals a new conviction for them. As a result, it goes back even further into the conviction process. So a case that was final, quote unquote final in the 1990s is now reopened in 2026. And it happens every single day. Okay. That would happen every single day once somebody's resentenced. And I've been doing appellate work exclusively since 1998. And I can tell you, there's cases I've handled for over 20 years because of serial PCRA petitions, federal habeas petitions. There's a victim on a capital case who calls me every couple months to check on our case because it's currently pending in the federal court system. And it's disheartening to these people that there's no closure. And what this will do, with the House bill would have done anyway, would have provided zero closure to anyone because those cases would be reopened and resentenced ad nauseum until the end of time. And I think that's the important thing that keeps getting forgotten is that these people were rightfully convicted. We're not talking about somebody who were exonerated. We're talking about people who were convicted. And now you're asking victims to relive that. And that process goes on for years, not just that moment in the courtroom. For them, it's every day. It could be every day again in a courtroom. And that's our position on it.
So at every stage, like when it's being, and we need a chart for all of that, by the way, thank you.
I wrote a chart before because it is that complicated. But that's the part that no one understands in the sense that it doesn't end. The PCRA Act has the ability to reopen cases after years, as long as you have after discovered facts, new law, things like that. In the House bill, your bill added an entirely different provision that never existed before, which I don't even understand what it would do. Because it sounds like it guts the time bar 100%. And after 30 years, someone could raise any claim they wanted, which I don't know about you, but I don't know if I'm going to be around for another 30 years to go deal with those problems. And so it's just unworkable the way that it's been designed. And the appellate process is much, much longer. And it's much more complicated than people realize.
Each of those stages where it is being, ping-ponged from court to court to court, and your office is involved, are you communicating with the victims' families at every step of the way? Like they're still waiting for their closure that may or may not ever come.
And that's correct. We are in contact both with the office of the state office of victim advocate, our local office of the Center for Victims. We have our own in-house victim advocates now, all designed to make sure that our victims are fully informed of what's happening in their cases going forward. Because unfortunately, it's never over. And that's the part that I think is hard to accept. And they just want to know when that day is going to be over. And unfortunately, I've resentenced juveniles. I told somebody, I said, look, I don't ever want to see you again. Okay. Because I want it to be over for you. And unfortunately, I had to call her up on the phone and say, I'm sorry. We have another petition that got filed. We have to talk about this again. And I had to bring her back in after we talked about the murder of her daughter and her unborn grandchild. And after so many years, it's very hard for people to live that again. And it's very hard as prosecutors to force people to live that again. And it's something that no one talks about is everybody's suffering from trauma as a result of it. The victims, the prosecutors, because it's hard. It's hard to relive old events. And it's hard to keep doing it over and over and over again.
Do the other counties, and Nicole and Bob, you can weigh in on this, please. My experience is only with Allegheny County. Do you all have dedicated attorneys that just do the appeals for your counties?
No, I do not. But we too also have in-house victim witness advocates. So some counties have them and some don't have them in-house. And we try to be a very trauma-assumed district attorney's office. We recognize people are coming to us on the worst days of their lives, and everyone in that office, from our support staff to our detectives, our forensic detectives, our advocates, our attorneys, wear it every day. And so we recognize that, and it's very profound for all of us. And I think that's why I think you can hear it in all of our voices, how much weight that carries on us. And, we live in the best country in the world. We're celebrating our 250th anniversary. We have the best criminal justice system in the world. And look at what we're still up against. we're still trying to figure it out. And I thank you for bringing us in and really asking so many thoughtful questions, because it means you really want to know what we think about it. And I appreciate that so very much. I think we all do.
No, we appreciate you being here, and I do want to just take the opportunity to get some additional suggestions. And I have read Senate Bill 1400, and it sounds like all of you are very familiar with it. And just by the way, Senate Bill 1400 was passed 3 weeks plus in advance of that 120-day deadline, and for whatever reason, the House just it didn't take it up. So I know it had that, the 35 to life. And there was some other provision, like if the defendant was over 70, it only had to be like 10 or 20 years. Bob, you specifically mentioned that you would have liked to have seen a more robust provision regarding robbery. Was there anything else in there, any other takeaways for us from that Senate bill that you would have, in your minds, made it better?
For me, looking at that 70 was kind of a question I had, and I just had not had the opportunity to look into that a little further. The idea that I have to look at a victim and say, your spouse's killer was 70, so he's looking at 10 years, versus your spouse's killer was 68, he's looking at 35. I think the victim is still dead, the family has still lost him. But I believe overall, understanding the process of having to go through a lot of different compromise in a lot of different situations, I believe myself, and I know members of our association, felt the bill really did address well the situation we're facing.
Okay. And I don't want to be a microphone hog, but I just have one more question, if that's okay with you, Mr. Chairman. And this goes back to something that you said, Nicole, about, preserving victims' rights, but also preserving those plea agreements. And that's where I had the question, because so for second degree murder, sometimes the juries are just, they're picking that over the greater charge for a variety of reasons. And also, when you negotiate that as a prosecutor, you're taking death off the table. So that's oftentimes a reason why a defendant would plead to that lesser charge. And there's, knowing they're still getting life without parole, and obviously not anymore. But as far as the plea agreement goes, and this might be a question for our attorneys with the House of Representatives, would we be able to statutorily do that if the Supreme Court has already invalidated those sentences? Like if you took the plea for life without parole, no death penalties off the table, and pleading, to this felony murder charge, could we constitutionally do that given the ruling? And I'm just asking because I don't know.
So I'm not sure of the answer offhand of whether or not that would be possible to happen. However, I do believe that it would be possible to say, if that defendant wishes to no longer abide by that agreement, that the Commonwealth has the opportunity of going back to trial should we wish to do that. If there was a situation where, we in Indiana County have a situation currently, we're waiting on 2 defendants to be sentenced. And they were going to be Monday as well. They're going to be later on down the road. But the idea would be, well, we had an agreement. This is what it is. And I believe if the defendants are no longer held to stand by what that agreement is, the Commonwealth should no longer have to stand by that agreement. Now, just the realities of life, maybe the Commonwealth is unable to say, well, that case is from 1999. There's no way we can go after first degree murder or the death penalty or anything else. So we don't wish to withdraw it. However, if it was a case from 2023, I believe the Commonwealth should have the opportunity of saying, well, if you're no longer standing by that agreement, we're not forced to ourselves.
Thank you.
Thank you, Representative Mihalik. Representative Razzle.
Thank you, Mr. Chairman, and thank you, panel, for being here. My questions are very easy, I think, answers, yes or no answers. And they're in regards to the amendments that were put on the underlying bill that prevented it from being passed from the Senate. Does releasing a rapist from a prison for completing a life skills class make our communities safer?
No.
Thank you. Do you think that an unrepenting murderer should be released on medical leave due to diabetes or COVID.
No, and certainly not by a physician that didn't even have to see the patient.
And we're-
That was a critical component
Well,
of the
that was actually
House
my
bill.
third question,
Okay.
which is, should a social worker be able to determine the medical status of an inmate and make a recommendation for their release?
No.
Okay. My last point. These are real things that were in this bill. And this is a policy point. The Democrat Socialists of America on their website have their policy points written out for America and for Pennsylvania. Two of those are to abolish prisons and, quote, liberate inmates. Do you believe that this very may well be their first step in that process?
To me, it's certainly a concern, and as prosecutors, we have two jobs: pursue justice and protect victims, and that sentiment is antithetical to both.
Thank you very much. From a personal note, uh, my family lost my grandmother to murder. When you were talking about families reliving those trials and reliving those issues, that really hits hard. I'll admit that's when I kind of choked up a bit while you were talking about that, because that is when you lose your loved one, you lose a soul that you love, you lose a person that you rely on, and when you go through that trial in that manner, you relive the horror of that, and in our case, a very unrepenting individual. So I appreciate the work, my family appreciates the work that you do on behalf of all of us, and to make sure that these people do indeed go away for the rest of their lives. Thank you.
Thank you, Representative Razzle. We have a question online from Representative Barb Gleim. Representative Barb Gleim, you're up.
Thank you, Mr. Chairman, and I just want to thank all the panelists for being here today. I do want to let you know that one of the letters in your packet from Stella Getchin, her husband was actually murdered in my district just about 12 years ago. And I had a chance to speak with her personally about her story. And so I would like to pass along some of the comments that a victim who will have to relive this because he was a murderer that pled down to second degree had to say about the process that happened here. But before that, just a little bit of background. The House Democrats have been trying to release harmful inmates for a while now. Last session, they had a bill where they were trying to change the parole board to, instead of being unanimous, to give someone parole that is a murderer to just 3 out of 5. So this has been something, a goal of theirs over time, and now we are dealing with this. And I just think it's a really harmful thing, especially to victims as well. So the first thing that she said, and I think that this really goes to what a lot of the panelists have been saying, is this should not be retroactive at all. If you're going to change the whole system, it needs to be from the time of the change going forward. It should not include people that had first degree convictions that pled down. It should only be for those who were truly convicted of second degree murder. And she said that 70 years old is not a thing. So those 3 things I think are pretty succinct, where a lot of the victims, she's speaking, I think, on behalf of a lot of the victims. And I will let you know that I am a victim as well. My father was murdered. I was 15. And I agree with one of the panelists that said he thought that somebody that is just trying to steal from somebody, I think they really missed the boat in the Senate bill on that one. So I agree with that as well. So my question is this: I can't remember which panelist it was, but they were saying there's going to be no uniformity on the resentencing. But will there be uniformity involved in the process for the victims? So are there guidelines other than the fact that they are due a fair trial? Are there going to be the same guidelines for all 67 counties in the state under this new bill?
I do believe under the Senate bill there would be providing some uniformity. As of right now, not only do the victims of secondary murder not have uniformity across the state, but they are going to have to deal with issues that no other victims have to deal with. They're dealing with additional problems as we stand today because there's no legislative framework. So not only have them and their families been victimized, will there be the incredible appellate process that we have in our state, but they're going to be dealing with additional problems and additional issues that other victims don't have to deal with.
Right. I don't see how they can get a fair trial if everybody or most of the people are dead that were in the original trial to begin with. Like, how is that going to be ruled fair?
It all depends on what reset. If it's retroactive, which I think ultimately it will be. As it stands today, it is not. But I believe the Supreme Court will make that decision, or the legislature will make that decision in the future. However, without a framework, you don't know what anything's going to look like. So when we did the juvenile lifer resentencings, there initially was no framework. The Supreme Court built a kind of a framework, and it was all built through case law. So you got wildly disparate results. And without a framework, that is what will happen. And you're talking about, I dealt with it when I resentenced these people where you had victims' families I couldn't find. Okay, and I could never find them. But the defendant's family members all had a chance to come in, and they all remarked about how horrible it was to visit their loved one in prison. And I even remarked a couple of times, and I've said it many times, is unfortunately that means, but the victim's family, the only place they can visit their loved one is in a grave, and it's a stone. And one of them talked about how they wanted their loved one to be, or defendant's family wanted their loved one to be home for Thanksgiving. And I said, well, the victim's never coming home. They're going to visit them on Thanksgiving in the cemetery. And unfortunately, that's the reality that we're faced with. You're going to have a lot of groups out there that are going to insist that somehow these people have been exonerated, or somehow they're worth less type of sentence. I mean, I have cases in our county that are actually horrific, where there was a man who raped and murdered a 4-year-old child, and he was convicted of secondary murder. There's no question he did it. He came out of the bathroom with a towel wrapped around him when he killed that little girl. He's going to get resentenced probably. There's no question he did it. He should serve the rest of his life in prison. And that's the situation we're faced with, where there is no finality, and some horrible, horrible people are going to have the chance to get out. In a way, if we don't have a legislative solution, will be chaos, where some judges somewhere, I'm not saying it'll happen in Allegheny County, I'm not saying in Westmoreland or Indiana, it'll happen. And there are people who believe that it should. There's probably at least one county I can think of that's what they believe will happen. And it's something we need to avoid. And the only way to avoid it is a legislative solution that's smart. And unfortunately, the House bill is not smart. The Senate bill is a smarter version. And that's no disrespect to anybody on this panel. I know you voted all against it, but I'm just saying it's not a smart bill. It's not forward thinking. It's not safe. And it only hurts people. It's going to hurt the victims. It's going to hurt the citizens of this Commonwealth. And it was short-sighted. I saw it as soon as it happened, it was short-sighted. And I know members of the House personally, and it was short-sighted.
Well, I agree 100% with that. And just like Rep. Razzle said, murder is a multi-generational. So my kids never got to know their grandfather, and their kids will never get to know him. And so it's to me, this is one of the worst things, again, that has happened in the House of Representatives since I've been elected. I have one other question, and that is, the legislative branch is supposed to be equal to the judicial branch, which is equal to the executive branch. If the judicial branch gives a timeline of 120 days, why can't the legislative branch give the judicial branch a timeline of 100 and, I don't know how many, 365 days for that matter? What determines that they get that timeline to impose on us?
That's a great question, but one I don't think that any of us can answer.
Okay. All right. I just appreciate everybody for being here and testifying. Thank you, Mr. Chairman.
Thank you very much, Representative Glein, for being willing to share that. Representative Cooper.
Thank you, Chairman, and thank you, panel. The question that I get from my constituents, and I'm going to just say right up front, I'm not a lawyer. A lot of my people aren't lawyers. So when you're trying to explain this, Joe, are we safe? Are we safer now? Like, what should I be worried about? And so I know, Ron, I was so glad that you went through what the definition of second-degree murder is when you opened, because it's so important for people to understand what that means. And so the question I get is, how quickly could these people get out and, harm us? And I think, Bob, you had mentioned something that I really didn't think about, which is how the resources are no longer being used to keep people safe in the community, but would be pulled away for something else. So my question to the panel is, from somebody who's not a lawyer, and you're wanting to explain to them, are we safer now, or how much safer are we? How much do I need to worry? Can a murderer get out on the street? How quickly to go through these appeal processes? And, are we keeping murderers on the street because we don't have people to put them away? So if you could just kind of give a general overview on that, so it can help me when I'm talking to people like, yes, this is something that can happen quickly, where other people say, you're just trying to scare us. So if you can clarify that, I'd appreciate it.
Thank you. That's a great question, and I guess I'm going to kind of answer a couple things there. One, most people we deal with aren't lawyers that we come across in our work. So I use a lot of examples from the medical world, because everyone goes and sees a doctor. And one of the things that I've talked with people in Indiana County about is this, especially with the appellate process, is imagine somebody breaks your knee and tears it apart. You go in, you have a knee surgery, it heals, you're on crutches for a little bit, it's done, right? Well, now with all these appeals that go up to the Superior Court, the Supreme Court, and PCRAs and habeases, and then the cornucopia of appellate rights, imagine as a victim, you get a call every 6-8 months. Okay, we don't know if that surgery is going to stick. We're going to have to go through it again and see if it happens. So I really try to use, items from the medical field, because that's kind of what people have. And, if you get a knee operated on, 20 years down the road, you might find out, oh, it didn't take. Now we got to go back and, you can't walk anymore, and we got to do it all over again. So that's kind of the example I use with reopening all of these sentences. Time-wise, I think it is something worth being very concerned about. Once our appellate court comes back, and I agree, I believe they're going to make it retroactive, you're going to immediately start seeing people seeking sentence. And, it's once they start seeking resentence, you're going to have a judge out there to let somebody out. And, I know the statement earlier was, the one district attorney who's not a part of our association in Philadelphia County, and they have 500 plus second-degree murder inmates that, are probably going to go through, and we can all read the news and see what that county may decide to do with them. But it's not something that's going to stay there.
Right, that was very concerning. I
Yeah,
agree.
it's not something that's going to stay there. In my county, of the 5 second-degree murder cases I have, the majority of defendants are not from Indiana County. They are from other counties. They're from Philadelphia. They're from Baltimore. They're from Tyrone. They're from other places. That train comes right from Philadelphia into Cambria County and disperses all over Western Pennsylvania. So, it's not something where they're going to say, hey, we're going to let you out, but you got to stay within the confines of our county. It is something truly for people throughout the state to be worried about.
Thank you.
Representative Bonner.
Thank you, Mr. Chairman. And I'd like to thank you and Representative Gatos for calling for this hearing today on this very important issue, as well as our testifiers, and for your service as well. This issue is of particular importance to me from 2 perspectives. First, I was a prosecutor for nearly 20 years, and I have some people serving life sentences for felony murder convictions in Pennsylvania. So this issue is of particular importance to me, and I'll be actively involved, hopefully, in the appropriate resolution of it. I also want to make a second point to Representative Gleim, and that is the General Assembly can tell the courts what to do also with the time frame. But just like the General Assembly, they don't have to listen to us. So we have that same mutual respect, or in this case, non-respect for each other on occasion. I thought it was a very interesting case that the Supreme Court chose to decide this issue, the Derek Lee case. Because when you read the Derek Lee case, that was an individual who, with another co-conspirator, entered a home and pistol whipped the resident of the home. They each had their own firearm. So this was a robbery and a burglary of a home by 2 individuals with deadly weapons. And if there is any particular felony murder that should carry life in prison without parole, and I hope the General Assembly will keep this in mind as we move forward, anytime a deadly weapon is used. When you carry that into a felony scenario, the likelihood of someone being murdered is very much present. So whether you're a lookout or whether you're at the front door watching for other people, when there's a deadly weapon in that home, we should clearly seek life in prison without parole. And as Judge Brobson said in his concurring opinion, life in prison without parole is still on the table. We're not saying that's unconstitutional, and we should approach this legislation with that thought in mind, that life in prison without parole for felony murder is still very much the law in Pennsylvania. I had a question, though, relative to retroactivity. There was a case in 1977, Commonwealth versus Sutley. And there, the Supreme Court of Pennsylvania said that the General Assembly could not wade into past convictions and tell the courts to go back and revisit past convictions and resentence individuals. I don't know if any of you had a chance to look at that case or how that case may impact this particular scenario, or whether you do have absolute confidence that the General Assembly does have the power to direct the courts and guide the courts in resentencing, or whether you feel that is still an open issue, that there may be some concern about whether the General Assembly actually possesses the power to tell the courts, go back and resentence in this manner.
Representative, the solution that I believe, taking out your issue, okay, was always to make them parole eligible at a certain period of years. That way we don't have to resentence people. Resentencing people is not a solution that's really truly viable for the people who have been incarcerated for as long as they have, because it puts everyone, including the victims, at risk. It's easier to let it be sent to the parole board and let the parole board have a framework to do that with. As far as retroactivity goes, the Supreme Court has been pretty clear on it. They is when the Miller decision came down, the argument was always going to be that that wasn't substantive, it was procedural. Okay, and then when Cunningham and the other name escapes me at this moment in time, but the point is when the Supreme Court decided those two cases, they decided it was retroactive. That's the same thing that's going to happen here. It's only a matter of time. I think it could happen before the end of 2027 or earlier. Because like I said, I know our office has one up there with the same issue. So finding a solution to retroactivity is relatively easy in the sense that it's not a resentencing solution, it's a parole solution saying, look, if you've served 35, 40, pick a year, I don't care. You've served that number of years, you're now parole eligible. You take off the problem the Supreme Court had, which is the idea that it was unconstitutional because there was no possibility of parole for someone who wasn't the shooter or whatever. So now they have possibility of parole. You've solved the problem. This was a problem this is the same solution that people in my office and in the court system suggested when Miller was decided. It was the same type of solution. They would have avoided it. The lesson we've learned from resentencing all of those people is the idea that all you're doing is hurting the victims. And that's what we're trying to avoid. And that's what I wish we could avoid and doing that again.
So do you think that the actual flooding will occur with the parole board as opposed to the courts?
Representative, right now, I have at least 15 to 20 PCRA petitions that I know of that are raising this issue. That's just since Lee came down. It's only a matter of time. I have 3 of them on my desk. I've answered one of them. It's only a matter of time. The parole board is better geared to being quote unquote flooded than the court system. The court system already is overburdened with the idea that we have to deal with the crime that happens each and every day across the Commonwealth. And in an appellate process, again, it goes through them as well. So the parole board, they already are geared to do this. I know in Allegheny County there were 3 people that were commuted from their life sentences, convicted of second-degree murder by that same parole board. In fact, I know because I ride the elevator with one every time I go to the courthouse. So I know it happens and it can be done, and the parole board can achieve it.
Thank you. That's a very interesting answer, and one will be very helpful to us.
Thank you, Representative Bonner. Online, we have a question from Representative Brett Miller. Representative Miller, you're up.
Thank you, Mr. Chairman, and thank you to all the testifiers. Question I have was in reference to something that was said by one of the testifiers earlier. Just to be clear, if no bill is established across the 67 counties, there would be different decisions made, and it's possible that a judge could say after 5 years, I'm letting a certain individual out. Is that correct?
If it's retroactive against anybody that's been convicted, the answer is yes. It doesn't matter. They can sentence them. When I did a juvenile lifer, that is exactly what a judge did. They sentenced him 7.5 to 15 years. He was ordered parole forthwith, and I had to appeal it in order to keep him there, and he tried to deny my stay until I took that to the Superior Court. So yes, it can happen, and you can get chaotic solutions. And then that's the problem, is if it's retroactive, that will occur. Now, as far as everybody that's been currently pending sentencing, it's a bigger question because no one knows exactly what to do. Without a framework, they can pretty much sentence them to anything right now. And it's going to everybody's just going to appeal it till it's solved. So everybody that's currently pending sentencing, including Derek Lee, are left in a no man's land of what to do with it.
Follow-up question then in reference to retroactivity. If a bill is passed with a framework, let's say the Senate bill passes, does that remove retroactivity? Does that take that off? Retroactivity still a potential if a bill is passed?
The Supreme Court will weigh in on this, and they'll probably decide. I'm betting. I don't bet, but I'm telling you now, it'll happen. They'll decide it's retroactive. Decide it's unconstitutional, and they'll do it. We just need to have a framework in place to solve it. The only way to have a framework in place to solve it is the parole eligibility solution that avoids resentencing, so that we take some of the unknowns off the table. That way, it's more controlled. And that's that's my office's position. It's been that position for years, is to solve it in a way that the victims aren't exposed to more trauma.
Okay, and then maybe a statement is a reference to Representative Mihalik and I think some others about items that we could put into legislation to make it better. One of them, I believe, could be from the General Assembly, put in a provision that disallows retroactivity. I believe there's precedent for that, and that may be something that the General Assembly will want to consider moving forward. So thank you, Mr. Chairman. Thank you to all the testifiers.
Thank you, Representative Miller. Representative Schaefer.
Make this relatively quick. Most people have answered my questions, but interesting scenario I was just thinking of is you kind of you referenced how a lot of times people who may originally be charged with first-degree murder plea down to second-degree murder because they don't want the death penalty. We're in a situation now, though, where if I'm sitting in your shoes, and maybe before I would have let someone plea down to second-degree murder, I probably wouldn't anymore because I don't know, there's no sentencing guidelines for second-degree murder. I don't know if there is a third-degree murder that sits below it that you would, so does the lack of, because right now we lack the sentencing guidelines, as I understand it, for second-degree murder. So it kind of creates a conundrum for you in that if you're looking at charging someone with different crimes, you might not want to charge them with second-degree murder. You might want to, if possible, like kind of hold to first-degree murder, or maybe even charge them with a assortment of lesser crimes to get the sentence that you want. Is that a correct analysis, or how do you do an analysis when you look at what you charge
I mean, I think it's certainly a factor, but there are so many things that go into it. And when I hear people say like plead down, it's not that we're bending the knee to a defendant. It's that it makes the most sense based on the case we have in front of us, the evidence that we have, and what our victims' families are saying to us. Can they sustain it? Do they want to go through with it? And so when in the past, being able to say to them, this individual will be incarcerated for life, that was sometimes more palatable to them. And they don't make the ultimate determination, the district attorneys do, but it all comes into play. So will it be a factor? Yes, because we don't know what's going to happen and the fear of the unknown. And something that Representative Cooper was mentioning that I know as district attorneys and prosecutors, we get asked a lot is, are we safe? That is a major concern for us right now, because if you have a mass exodus from incarceration of individuals into your communities, how then also does the community react? And in the world we live in today, that can be very vitriolic, and we all face it, especially those of us that are electeds, that's dangerous. It's just very dangerous. On top of it, all of the other dangers we mentioned, as Representative Cooper mentioned that, I also wanted to weigh in on that factor. We don't know the public reaction when an individual is released into a community. So I leave that with you as well, and that's very concerning to us. It's almost like for the district attorneys, it's sand through our fingers. You know, we can't stop it, and we don't know what to do with it, and we're coming to you to say, help us, because we have a job to do, and when we don't have direction, and we don't have case law, and we don't have clear statute, it makes it very difficult to be able to have the consistency that we know and believe to be good for the Commonwealth and the residents of Westmoreland and all of the other surrounding counties.
Any other questions before I ask mine? All right, well, I have one very brief question for you guys. I think that nobody understands better how important this issue is than victims' families. But for those individuals watching on the live stream today or reading about this issue in the press that have been so fortunate to not have been victims themselves, the families of a victim, can you explain why this issue matters to them, why this issue should matter to, hopefully they are never victims themselves, but we know there are going to be future victims. Why should this issue matter to people who have not yet personally experienced the horror that criminals have exposed and brought upon their families?
So, and that's a great question, and we face that a lot with saying that. Why should I care? Because your children become teenagers and work in stores that get robbed, because you have individuals in your community that may know that you work hard and you have things of value in your home and they come and burgle your house, because you have sons and daughters that go to college and they become victims of sexual assault with firearms. Because the last thing you want to do is sit here and not care about this subject, and God forbid you or your family become victims there, and there's just no protection for you or for them.
Well, thank you very much. I want to thank all of you for taking the time to be here today. I want to thank all of the members for being here. I'd like to turn it over to our host, Representative Gatos, for a final question and some closing remarks.
Well, I think many of my questions were answered. And in fact, I knew this was pretty egregious, but hearing this over and over again, how tragic this is going to be. I mean, without a sentencing framework, we're what was imparted on our state was absolute chaos. And I'm concerned about the safety, our public safety, and I'm concerned about our individuals who trust our government to have uniformity and to see that this legislation was put forward wholly unserious. I mean, that's what makes me mad, is that I knew it was a bad bill. And I voted no, because we need to be serious legislators. And to see that this piece of legislation just put our system into, our judicial system into chaos, lack of uniformity, is disgraceful. I wrote a whole bunch of notes here to try to have all these takeaways, but that was really my huge takeaway. We did get it right when we were supporting Senate Bill 1400, which unfortunately was not taken up. And that sounded like it got it right pretty much in a bipartisan way. And it had all of the parties involved in making that legislation. 1042 made a mockery of sentencing, and that making this retroactive is completely egregious, because of all the things we talked about, is that it doesn't give our victims the rights that they deserve. And as we talked about, that it was for, it's not for people who pled down. They pled down to second degree, so they clearly had higher sentences, not lower sentences. And again, this just goes back. I mean, I kept writing, this is putting our judicial system into chaos, and it is putting public safety at jeopardy. We're going to work hard to try to get the Senate bill going forward. We promise you, and we promise all of our constituents, that we will make public safety the top of our priority, because as DA Ziccarelli said, we live in a great nation, and we are here to protect it, and we're not going to let chaos take over. So thank you for testifying. Thank you for everyone being here. Thank you, Mr. Chairman, for bringing this up. And thank you to my colleagues who are fighting so hard to keep our community safe. Thank you.
Thank you, Representative Gatos. I think today's testimony, the deeply personal letters that were shared by Mrs. Getkin and Ms. Hickman, remind us that no court ruling or legislative action can undo the loss that their families and families like theirs have endured. But we can ensure that their voices, the voices of every victim's family, are heard and respected as Pennsylvania determines their path forward. To steal a quote from the policy hearing we had in Hazleton, one of the district attorneys there shared with us that this is a difficult issue, but the solution is not letting murderers out of prison. The solution is justice for victims and closure for their families. A statutory sentencing framework must recognize each offender's level of responsibility without minimizing the seriousness of these crimes, weakening accountability, or placing our communities at risk. Victims' families deserve more than uncertainty. They deserve meaningful participation in the process and confidence that the justice system will never forget the life that was taken. I want to thank again Mrs. Getkin and Ms. Hickman for trusting us with their stories, and our testifiers for sharing their perspectives and experiences here today. I want to thank our hosts, Representative Gatos, Representative Mihalik, and Representative Schaefer for hosting us, and once again, Moon Township for allowing us to use their beautiful facility. We will be continuing our focus on public safety when we reconvene on August 19th for a hearing with Representative Weeknecht in Reading on recruitment and retention for law enforcement. Until then, this hearing is adjourned.